that connection, that increased risk, whether it be heightened crime in the community. I just had a case recently where that was just the very factor. And this individual who is in criminal custody now was likely on some substances and came up and shot and killed one of my client's workers. And there was nothing to necessarily indicate that there was any personal motive or anything specifically as to this individual. However, an opposing counsel, appropriately contacted the local authorities and got me the data information to show that there was a heightened risk of violent crime. And that's what Joe was talking about. Crime itself is not really going to be the tipping point to show that there is an increased risk. It's got to be a violent crime to show that by my employer putting the employee at that area, they have thus increased the risk of a violent type of assault of happening, which had happened in my case. Now, there may very well have been evidence at that rest stop that there was violent crime, but it wasn't induced. And I think that's why the commission correctly found the way that it's did. And even after the Court of Appeals reversed, then got to go through and still failed to produce that evidence. So as a practitioner and for those representing injured workers, that's I think the real thing when you looking into these cases. What can I find to tie that what happened to my client was increased there? Those cases were with the bank robberies, those are kind of easy because unless there's a personal connection there, it's pretty evident if somebody's coming in holding a gun saying, stick them up, give me all their money, and the person gets shot, that's an increased risk of being the bank teller. But when you don't have something that cut and dry, you need to be thinking what it is that's going to connect this heightened risk that's been caused about putting this person there. Think of the pizza delivery driver case, and this has happened, I know, more than a few times, where they go on a call or they go into a neighborhood. Now, the cases, I think, would be cut and dry if they go to deliver pizza to somebody's house. Guy says, stick them up. They end up scuffling, getting shot, and I've had that case. That's clearly going to be compensable. But how about the pizza driver that's just driving through a neighborhood and a stray bullet goes through? I know Joe's got a case right now he probably can't talk too much about where the person was not the intended victim on things. But if the pizza delivery driver or whatever kind of driver it is for that matter is an area that there's an increased risk of shootings, of violence, and those type of activities, the employer needs to be aware that there is an increased risk for that reason. And a claimant's attorney needs to equally be able to adduce and obtain the evidence to show that risk to the commission. Otherwise, they can't just make that assumption, and the commission had to find the way that it did on the King case.
Right. So in the materials I mentioned this Roberson v. Wetzel case, and that drills down. That was another Court of Appeals case, and this guy was actually, he one of the things he had to do to get between with this building where he worked and the main office where he had to go to get his paycheck and do other things. He had to go right through this area in Leesburg, which I guess at the time back in 1995, this was a bad place. There was a place called Loudon House, and it was known for discharge of firearms. This is what was going on over there. There were always gunshots over there. And he's driving past this place. He gets shot as he's driving past this place and killed by a stray bullet. And the town manager of Leesburg, so this is obviously the claimant's attorney called the town manager, said that Loudon House had a higher incident of police activity than any other place in town. And the crime statistics showed that the area of town had the highest incidence of criminal activity, and that Loudon House, where he drove past, and what they figured out where the shot came from was actually the center of that activity. So the court found that he this repeated exposure to the heightened risk, not only just one time, this guy had repeated exposure to the heightened risk because of his job. So somebody like a cashier or somebody like that, you can think about who maybe they have to work all night and they're in a high crime area. They're having repeated exposure to these risks. So even if they get hit by a stray bullet, I think that's going to be a compensable claim. So that's so you've got either the character of the job, because the job presents a higher risk, or the character. There's the risk probability of risk is augmented because of the area that they're in. Let me see here. I give some other examples here. You want to address that?
Sure.
Steve?
And I apologize, Joe. You had invited me to talk about the R&T investment case that's in your case laws there. That was a 1984 case. I think this was pretty much a cut and dry case as far as compensability. And you had somebody who was, as part of their jobs, required to carry large sums of money to take it to the bank, did it routinely. And therefore, that the Supreme Court properly found that putting somebody in that position of risk was an increase of risk that what eventually would happen. Again, I think those are probably the easier cases because the very nature of what they're doing is going to put them at that increased risk. Rarely are these cases ever going to be where course is going to be at issue with things. And so as practitioners, it's really going to be what's putting it at the at-risk stage on things for cases like assault or even horseplay for that matter. And I don't want to really gloss over it too much since I brought it up. But, going back to the Hilton case, for years it was just assumed that, or not assumed, it was well established, I should say, by the Garment case that horseplay was considered a risk of the employment. Employees working long hours together, having a relationship, they're going to be prone to blow off some steam. And therefore, when things like that happens, that's just going to be a risk of the employment. Where Hilton changed things, and again, kind of threw things into kilter, I think it was eventually righted, is that it was the personal motive of the person who did the bad act in this case. And it wasn't even ill-intended, but it was a very sad and tragic case whereby two EMT technicians were riding in an ambulance. We'll just call him the assaulter in this case, either had a crush on or was just known as a prankster, but he came and picked up some defibrillators in the back of the ambulance. And as a result of that, did not check, well, I shouldn't say as a result of, but did not check to obviously see whether those defibrillators were active. Did one of those, gonna get you. Well, unfortunately, he got her, and it was charged, and she died as a result of it. And it would have seemed that would have been a horseplay type of case. But the Supreme Court said no, and in this instance, because of the exclusivity rule, it was challenged in a plea and bar, I believe, whereby it was taken to the circuit court and eventually the Supreme Court saying, nope, comp bar applies under 65-2-307. Only remedy available is under workers' compensation. Now, as an employer practitioner, and I'm not sure how many aware of this.
The circuit court said that.
Circuit court did. As a practitioner, I don't know how many aware of this. Claimants aren't the only ones who can file applications to have a case found compensable. I've done it myself at least 2 times when it was clear that it was a work-related injury. And then, and I don't want to step on Joe in this, but this will kind of segue is why Hilton was important. Then, as a practitioner of representing injured persons, whether work comp or personal injury, it's going to make a definitive difference whether your recovery is going to be limited to workers' compensation, and it's statutorily set forth with limitations of 500 weeks if there's beneficiaries, or whether they're going to be able to pursue and get a recovery at law, maybe under a wrongful death or survivor statute or something of that nature. And so the compensability and the increased risk of the employment, because Virginia is an increased risk state, is going to be of paramount importance when you decide how you're going to handle that case as a practitioner for injured workers or injured or killed persons. Likewise, as someone who represents employers, it is far better, at least for financial reasons, for an employer to have a case with the protection of limitation of workers' compensation. injured worker or a killed worker or somebody like that has a chance of a far greater recovery, subject to all the defenses that would be involved under common law, like contributory negligence, things of that nature. But it's the battle, I shouldn't even say a battle, but it's the quandary of, if you're representing employers like I do, is how do I best protect my client? If this is truly a work comp case, if it was an instance whereby a shooter came to a government building and shot people in Virginia Beach and there's no personal motive connection to it, then it's much better, at least from the employer's perspective, to have that case covered under workers' compensation. And so an employer can actually file a claim with the commission and have that matter be decided as being compensable. And I would think that at that point, once the commission makes that determination, that it would be recognized by the circuit courts upon a plea and bar. I will tell you an anecdotal story that I had probably 15 years ago, and really was the last time I had to go to a circuit court trial. But we had a case, brought in an employer's application. There was a worker who was picked up every day in a van to go to a work site by a co-worker at the boss's direction. Well, it was up in Northern Virginia. There was some unfortunate road rage going back and forth, and this young man was killed during the incident. Because the employer provided the transportation, amongst the other evidence that was introduced, I want to get into detail, the commission found that case compensable. Meanwhile, while that's going on, the estate of the young man brought a case in the circuit court. And the circuit court said, okay, I see you've got a plea and bar. I see you're claiming exclusive remedy type of case. We're going to hold things here, and I guess we'll find out, what the commission says. Well, the commission found it compensable. It was appealed to the full commission from the deputy commissioner, who affirmed that, and then it even went up to the Court of Appeals, which also affirmed that it was compensable. Well, the circuit court judge, very good judge, by the way, I don't mean to suggest otherwise, was just convinced, I think, that that's just not equitable, and we're going to have a trial for wrongful death. So we had a 4-day jury trial in circuit court of Fairfax County based on a case that the Court of Appeals had already ruled was a compensable case. Because the judge thought that there was a distinction in that case, that he was able to not apply the comp bar to the case involving this unfortunate young man. We got a defense verdict in the case. The judge took away the verdict, ordered a new trial. The timing on this, which is why I'm going through this, was very important, because while a new trial was being scheduled and we were getting ready to go up for calendar day, if any of you ever have been up in Northern Virginia, they do a lot of docket call calendar type of things. The Giordano case came down, and Justice Powell, writing for the Supreme Court, really, I think, put an end to the question of the exclusivity rule, and if a case is compensable, whether survival or wrongful death case can be pursued on those grounds. I really thought that would have been the end of that issue, but I think Joe's going to tell you, because he's very familiar with the case that's going on in Virginia Beach now. He's not handling the PI case, but I think he knows the one it is, where it's being pursued as a personal injury case.
Right. So for a second to go back to the Hilton case, because that was important. What ended up happening is the father of the girl that died in that case, that's the one with the paddles, she was shocked, and she actually, I think she went into she started having seizures, and that's how she died. But the father had actually filed a lawsuit against, the ambulance company, I think against the person that tried to save her, alleging medical malpractice and assault and battery, etc. And as was mentioned, as Steve mentioned, the circuit court upheld the plea and bar. So what happens in these cases, which is interesting, is that, to me, is that the roles actually get reversed. I'm a claimant's attorney, so I'm always trying to prove, the claim is compensable. And he's defense, he's trying to prove it's not. Right? But in this type of case, the roles are reversed. I'm actually trying, if I'm the plaintiff's attorney now, I'm trying to go into civil court and trying to do action for damages. I'm actually trying to prove that it's not compensable, right? Just so we're clear. So it's a little strange that the roles are reversed. Well, the Supreme Court of Virginia in that case reversed the circuit court and said, no, this assault that this guy did had nothing to do with the job. He had amorous feelings. In fact, I think they said he was known to harass his female coworkers. I mean, he was like I don't know if he went so far as Weinstein or whatever. He's like one of the early Me Too person, right? And so, it was all an amorous thing. It had nothing to do with the job, and that therefore the short circuit court should not have granted the plea and bar, and the personal injury action, which I assume was a wrongful death case, could proceed. And so that's what they found out. And that's what Steve was referring to. You've got these two cases. You got a couple of cases now going on. One is this Abigail's Warner case in Virginia Beach, and this is in the materials a little bit. I'm not going to sit here and speculate how this is going to turn out. I think nobody can. But what we know so far is this. This 6-year-old kid, everybody's heard about this, in first grade, comes in and shoots his teacher. Okay, I think she shot her in the shoulder or something. She's made an okay recovery, but she's pretty hurt. Almost immediately, I'm pretty sure the employer came in and said, we're accepting the claim as compensable. She was at work, et cetera. It's, whatever. It's a compensable claim. We're going to cover her under workers' comp. I believe it's Billy Bright. I might be Steph Grana. I'm not sure if she's on it too, but they file a lawsuit against the school board and the city for I think $40 million. I believe it's Newport News. Or it was Newport News or Hampton, but what? Yeah, $40 million lawsuit. And so now the question, so how is that the case if they've already accepted the claim? Well, nope, there hasn't been a ruling yet as to whether it's compensable. They're just accepting it as compensable. And the statute says there's an exclusivity provision in the statute, which is 65.2307, right? But it says the employer and he, meaning the employee, have to accept the provisions of the title. Well, she hasn't accepted the provisions. She is not arguing that it's compensable, meaning Mrs. Zwerger is, only the employer is. So now, what is his theory, as I understand it? And I'm just getting this. I have not spoken to Jeff, so I don't know, but I saw it in the paper, and it's an interesting theory. And if you think about this, there is no expectation for a first grade teacher to get shot by their student. Okay, you're talking about a 6 or 7. I think it was a 6-year-old kid. Okay, so and what we look at here is what was the kid's intent? Well, I think it's interesting. A 6-year-old can't really have mens rea, can't have intent, right? We know this from the law, right? So he's under 7 years old. So what kind of intent can you ascribe to this kid? I don't think you can. So it's going to be interesting how this turns out. It's interesting that the judge, as I understand it, has allowed discovery to proceed so far on those issues, on all the negligence issues. Like, what did you know and when did you know it about? I mean, apparently the school knew that this kid, people at the school knew this kid had a gun, and nothing was done, or nothing. And he was a problem child. He was violent. So we'll have to see how that turns out. It's interesting, but so far it's looking like the judge is starting to lean in that direction. Yeah.
Not about that case specifically, but I can tell you from the perspective of somebody who adjudicates these cases, there seems to be a presumption that an incident is either workers' compensation or it's an assault. But many of these cases are both.
Right.
And I mean, you can't separate them. I mean, I could punch Bill in the arm. I'm just being playful. For me,
He could still reach you.
I wouldn't do it because I know what would happen. But to me, it's horseplay. To him, it's an assault, legitimately so. So it's very, very difficult. And I'm sure. I mean, I could not be any happier that they filed that civil suit because I don't want to have anything to do with that. Let that judge decide. But I think in decided, and I had one recently that was very, very difficult. Almost needed a brain transplant by the time I was wading through it. God knows what will ever happen to it on appeal if it goes to appeal. But it's just not clear that something is workers' compensation or assault. It's really more a question of how it comes up procedurally.
Right. Well, I mean, also it also depends what the evidence is. I mean, in these cases, apparently there is evidence of negligence. I mean, most of the time when you have these things, nobody's at fault. It's just one of these things. I mean, who are you going to sue? You're going to sue the employee? I mean, they're it's just something that that happens on the job. It's not, or it could be from something that's outside the job. We don't know that there's going to be a viable theory of negligence on the claim to begin with. So sometimes workers' comp is your only option, or Tabitha's your only option, to go to the Virginia Victims Fund. But I appreciate that, Your Honor. What were you
Say
saying?
something real quick. At the expense of getting a call from Commissioner Newman reminding me that he does not want to see this case, as a practitioner for the employer, I would be thinking kind of what I was talking about before in filing an employer's application and finding that evidence to support the tie to the added risk of the case. And I honestly don't know if that's been done yet or not, but it seems to me that there would be two ways. And Joe does, I think, make a good point that, how far is the testimony of a 6-year-old going to go as to their intent? If you can even get that, because I'm sure there's, other criminal juvenile matters going on as it relates to that. If I'm not able to get that as a representative of the employer or the attorney of the employer, then I am going to be looking to see about reported instances of violent crimes in that school or in the area. I don't know if that's done yet. My apologies in advance if that application does come to be, Commissioner Newman. But, again, we're flip-flopping the roles here. And if I, as a attorney for a lawyer, want to get the exclusivity and the single exclusive right of the Workers' Compensation Act to apply, there is that option. And I think that that's what an employer's attorney would need to be thinking. Thank you, Joe. Right.
So I think what Your Honor was referring to is that this has actually been codified, at least with respect to sexual assault, in 65.2301. And that's the next subject I wanted to cover real quick. And what they codified, they basically codified this R&T and Wetzel case, legislated by saying, you get sexually assaulted at employment, where the nature of such employment, this is 65.2301, where the nature of such employment substantially increases the risk of such assault upon a proper showing of damages compensable under this title, that injury or that assault shall be deemed to have been suffered arising out of employment and shall have a valid claim for workers' compensation benefits. You also have to report it to law enforcement. That's the other thing they require. Then there's the Section B, which says, notwithstanding any of that, they put it right in the statute that the victim, sexual assault victim, actually has the option of pursuing an action at law. And says that if they want to go that route instead of the other route, and they have that option. And so they just basically codify this whole increased risk thing as it pertains to sexual assault. And if you can show that, the increased risk of the job for that, and you can show that the matter that was promptly reported to law enforcement, then the injury is deemed to arise out of employment, and you've got a compensable claim. I did want to bring up this one, is that this is not, though, the exclusive means of proving sexual assault. I mean, as I understand it, the section really provides a codified identification, correct me if I'm wrong, of jobs which bear an increased risk of such assault. But sometimes, let's assume that, and there's a case like this, the person is attacked in this way specifically because this is their job, and this particular job lent a very high risk of this, or the person was attacked because of the job that they had. This happened in this case back in 2014, a commission case of Bella Frick versus A Plus Economy Lodging. Real quick, tragic case. What happened is that this gentleman, I can call him that, this person, animal, decides he's going to assault the hotel clerk. And so he calls the front desk and poses as if he's a guest and does this ruse and say, look, I'm having a problem with my key. Okay? He waits for her to come up, the stairs, and he says, come up to room 222. My room's not working. My key's not working. As soon as she gets there, and he knows she's got the master key, right? She can get into any room. He assaults her. He grabs her, tells her to open room 220, goes in there and into room 220 and sexually assaults her. So the commission found that the way the evidence established that the attacker's deceptive call to the claimant was used to perpetrate the assault, and this was based on the claimant's status as a front desk clerk. In other words, because of what she did, because this was her job, because he knew that she would have the key, he had an opportunity to do this, her status as an employee and the ability to open any hotel room this was why they found that this was connected to employment and she had a valid claim. You want to get into sudden shock or fright before we run out of time?
Sure, absolutely. And I'll make
6 minutes.
6 minutes. One real quick point on that. That statute now changed. That's a carve out that the General Assembly has made to the exclusive remedy under 307 for the sexual. So I guess, I don't know if that case preceded it, but in that instance, if it were to occur today, the person who was assaulted sexually would have the option to pursue under an at-law remedy or under workers' compensation.
Right.
Sudden shock or fright. Again, I alluded to it earlier. What is it? Well, it is the legal standard. And what is a sudden shock or fright to you and me versus a sudden shock or fright, at least the case law opinion, to maybe somebody who's in the Department of Corrections?
So we're talking about pure psychiatric injury.
Yeah. Pure psychiatric injury, which you can have in Virginia without an actual assault under workers' compensation.
PI.
Certainly not under PI, because my understanding it's been some time that you do have to have the physical impact accompanying the psychological trauma. There are some presumptions for our first responders and certain people that are available under the Workers' Compensation Act. There's a fairly new statute that I did want to bring up in my course of discussion with my colleague up here on its impact, and I don't see him here, but I know Adam Shaw had a case where he represented a worker.
Beam v. City of Chesapeake.
Yeah, you want to take that because you got that there?
Yeah, Beam v. City of Chesapeake. And sorry, Commissioner, I didn't like this case. I have to tell you, I really didn't like it. Basically, the statute, the 65.2107 is something that was passed, I believe it was in 2020 by the legislature, and it gives first responders, firefighters, and policemen up to 52 weeks to prove a PTSD claim. It basically says if you can show an incident, just very quickly, if you can show an incident, an identifiable incident, then you got 52 weeks of benefits. That means medical benefits, and it's considered a valid compensable claim if you can show that, and you got to show PTSD from whatever this identifiable incident is. What the B&K has held is that is exclusive. In other words, every cop, as I understand it, every cop and every firefighter is going to be limited to that 52 weeks if they file a claim for PTSD. What I think Adam, I don't have to see Adam here. I don't think what he tried to argue is it's not. There's no exclusivity to that. Let's assume this firefighter has had one too many traumas and he can't go back to work on a permanent basis. As I understand it, you're saying the way you all read the statute at this point, what the language that the legislature has used is going to limit that to 52 weeks. And if they want to make, another claim on another incident later, they can go make another claim for another 52 weeks. But that's it. Does that pretty much sum up what Bean said?
I think so.
Yeah.
But you said you didn't like the case. There's a whole different universes of cases that I decide the way I like them.
So, but what you get for all that, I did like the commission pointing out, take it up with the legislature.
Right. I think that is.
It's an invitation, I think, for there to be a fix to it, because obviously the commission is limited to the statute as it's written and to a degree with case law.
Is Lorraine here? Lorraine's not here. So Lorraine and I had a case when she was the defense attorney, real quick. Just illustrate this sudden shock or fright thing real quick. I represented a woman who was a attendant at a assisted care facility. And this is just really illustrative of this sort of thing. And, she gets a call from one of the residents, says, I'd like you to come over here. And so she comes over to the resident's place. And when she walks in the door, the resident had just blown her brains out, blood everywhere, smelled the smoke of the gun. She had never seen anything like this before. So Lorraine, I don't blame her. I'm sure she got her marching orders from the carrier, defended the case and said that's not sudden shock or fright. So obviously I argued otherwise and said, look, this is not a police officer. This is not a firefighter. This is someone who's never been exposed to anything like this before. She's an attendant at a, assisted care facility. And, fortunately, the deputy commissioner agreed with me and we did okay on that case. But that's really what it comes down to on these sudden shock or fright cases is what kind of job does this person have? Are they routinely, is it part of their job to be routinely exposed to things like this? I think a police officer in the same situation probably would not have had a valid claim if they had PTSD from witnessing that event, if they were the type of police officer that's out on the beat and witnessing violent crime on a regular and frequent basis.
Prior to the presumption. Yeah,
Yeah.
I agree.
Well, prior to the presumption, yeah,
Right.
yeah. Now it's different, but
Right.
that's yeah.
So we have inside of 10 minutes, and I really do, as much as I like to hear myself talk, I really do, because this is such an important topic on things. And I'm personally grateful for you all being here, for Joe giving me the chance to do it. But I want to have some time for interaction and questions on things. So if anybody does, please raise your hand. If not, Joe and I can continue to the end. Sorry. I'll come back to you, Brad.
Are acts of war compensable in Virginia?
Yeah. So my take on it is like any work injury case, which we're here to talk about today, if you can show the nexus of the increased risk of the employment tied to the attack. I've never had that type of case. I've known people who have had cases where there were terrorist attacks on planes. That case actually settled. I think Greg Harbison was on that case, so he might have a little more insight on it. But I think the legal standard would be the same. And if you're representing an injured or a killed worker on an acts of war type of case, the same legal standard is going to apply. Brad?
Yeah, going back, you mentioned the teacher who shot one of the students, and
Should
the
take that
school
one.
basically said they wanted to accept that one. Then you pointed out, if you were the employer or the attorney for the employer, you would recommend filing a claim and getting something in place. But absent them filing a claim and having a hearing to make that determination, can that teacher actually accept it? If they accept the claim and say, we're accepting workers' comp, we're gonna pay your bills, we're gonna offer you wage loss, can she accept those voluntary benefits and not have the comp bar apply, or does that comp bar only come in when there's actually a determination?
That's a great question. So, what I think Brad's question is if the employer and or carrier, because they're considered one, decide, hey, this is a compensable case. We're going to pay this lady benefits, but we're not making any attempt to send agreement forms, which, oh, by the way, is required by the commission. If there's an agreement, you've got to present the claimant with agreement forms. And if they don't, they do it at their own peril. I think that would be one probably that would have to be argued, assuming that if the first time it came up would be a plea and bar as an initial response to the complaint filed in the circuit court when they did that. Again, if I was the defense attorney on that, I would recommend to my client, you're accepting this case, send agreement forms to the injured worker or the beneficiary. If they don't sign it and return it, then you can consider whether you want to file an employer's application to ask the commission to adjudicate the matter, whether it's compensable or not. Is that?
Steve, with those, I tell my clients don't accept it. Don't accept the payments because the statute says pay and accept compensation. That's all it says. It doesn't say an order has to be entered. So when I've had that scenario, if they want to pursue something, I have to tell them don't
Right.
accept the checks.
So thank you, Stephen. I mean, that may very well be right on that point. I sure wouldn't want to have to argue the case, go to trial like I had to do those 15 years ago, only to have the high court finally say, no, it was barred by plea bar anyhow on things. So as a claimant's attorney practitioner, and I think Mr. Harper is an excellent one, that's probably a very good practice rule on things. And that way it's unequivocal that the injured person or the killed person's beneficiaries is not seeing the case as a work comp case. As tough as that may be, because the need for payment of benefits may be immediate in the interim. But I think it's a good practice point that Stephen has, and it probably removes any dispute whether a defense attorney such as myself could go in and say, they accepted work comp benefits. They accepted that this case was compensable. They accepted that this case was subject to the limitation of 307. Brad.
Follow-up question, this is probably more for Stephen. The employer voluntarily pays hospital bills. The employment has no idea that that's even happening. How do you try to undo that?
Yeah, I think that would be that would be a more sticky wicket because one,
They're
they
just going
would
to have a lien. They're just going to have a lien on
Again, the
them.
statute says pay and accept compensation, so medical benefits, not necessarily compensation. You look at some of the other.
I agree with you, but then I remember there was some confusion about what the interpretation was of compensation under 708.
Yeah, but now they've amended the statute. The
They did.
Compensation is,
Right.
indemnity, it's not medical under 708.
Right.
For 708C purposes.
I think it would be inequitable to hold a injured worker to that bar to pay medical benefits, particularly if they're not aware of it. But again, I think Mr. Harper offers probably the best practice advice if you're a claimant's attorney on things.
That's why I was emailing when I have questions about this.
There you go. There you go. Yeah, from a defense side, employers and carriers, they make voluntary payments of medical benefits, whether the case is ultimately compensable or not. It happens. And as practitioners, we don't want to dissuade because there's a public interest sometimes in doing that. It gets a little bit tougher when you get with cases where the injured worker's on Medicare and some implications there. But definitely, thank you, Brad, for the question, and thank you, Stephen.
Anything else? Any other questions? I just in the last couple minutes, I would like to just take a minute just to say, just from the claimant side, one of the things, the human side of this is really what strikes me as most difficult sometimes. I mean, we've had clients that we've dealt with, that are just it's my paralegal can tell you it's every day it's something else. And sometimes these folks, and it's not their fault. I mean, they've been traumatized. And somebody that has a case of severe PTSD, you don't know what you're going to get on any different day, on any given day. And so, and it's also, as I talk about a little bit the materials, you got to alter a little bit the way you deal with them. And these two young ladies, Ms. Thacker and Ms. Fout, had a beautiful article at the Virginia State Bar back April 14, 2023. Trauma-informed representation, practicing with empathy, and I've lifted a few things, and I had their permission to do this. I called them, and they said, yeah, fine, and I'm augmented a little bit with it. But the main thing is just to, you got to lead with this empathy. Some days you got to understand it's just for your client to get out of bed. You probably see this all the time, and the other thing is, you've got to be able to validate what these folks are going through. The anger level is so high that you just got to be able to try to validate and understand what they're going through, and not kind of blow it off and just say, "Hey, man up!" and why don't you man up and stop whining all the time? And we don't. This is what they're getting at home. This is what they're getting from their spouses sometimes, and they don't understand what PTSD can do to a person. And so, what they recommend, and I think it's true. You got to gently affirm what they're saying, and just, I'm so sorry this happened to you. I mean, I think those are some of the best words you can say, and they say this too. That's very unfortunate. I'm so sorry this happened to you. I'm so sorry. It must be really hard for you. These kind of things sounds like platitudes to us, but to the ear of somebody that's going through something like this, that can mean the world.
I at times go back to a basic on dealing in these situations because sometimes you don't have the words. I mean, we're seeing a lot of cruel, evil things going on in the world right now. And meeting that with a little kindness and understanding and listening and connecting on a human level, I think is still what makes us great as a nation and as human beings. And so I'll just conclude on that.
Thank you all so much for coming. I appreciate it.